Okay, so last class we completed transfer of cases and disposal of property. Today we will see irregular proceedings. Okay.
Irregular proceedings, yes.
Yeah, irregular proceedings.
Hey, before we continue, I wanted to inform you about my live mentorship program for LLB students or law aspirants. Law subjects and law topics need detailed clarity. We get that with the help of cases, examples, and detailed explanation. It's definitely not possible to include everything in these short videos. If you find my videos easy to understand and you are looking for some professional help in preparing for your examination, you can join my live mentorship program. Here you will be getting exam tips, answer writing skills, detailed notes that you can refer for your examination, cases, examples, and in a very easy way topics will be explained. I have live classes going on for a lot of subjects as of now. To know more about it, you can drop me a message on this WhatsApp number. I'm also helping a lot of students in writing their assignments. If you need any such help or for any queries, any suggestions, you can drop me a message on this WhatsApp number. And now let's continue with our video.
So when we talk about proceedings, right? Proceedings are nothing but what happens in the court. There are different processes, different proceedings followed for a lot of different things, right? There is inquiry done by magistrate. Magistrate may issue summons, warrant. So many different things happen in the court for entire trial or whatever, right? So proceeding as in all those different processes, different proceedings will be covered. And when we say irregular, as in there is some problem with it. It was not done in its proper way, how it should have been done, or maybe it's done by a wrong person who is not having authority to do it, right? Like irregular, we say, right? Irregular. Same way as irregular proceedings, something is wrong with the proceeding. Okay, proceeding happened, but something is wrong with the proceeding. So what will happen in such cases? Is it that entire decision will become invalid? Is it that it had to be decided again? What will happen in case of irregular proceeding? Okay, so we will see this part again when we talk about criminal law. It is to protect interest of the society. That is the main purpose, that everyone should feel safe. If something has happened to them, they should get justice. That's the main purpose of criminal law. They want to punish the criminal, to teach him a lesson as well. But there are many examples or instances where irregularities have been committed, which may be curable irregularities or incurable irregularities. It might be something which you can fix, or it might be some kind of an irregularity which you cannot fix. Okay, so there are all these different types of irregularities that we often see happening. And when we talk about irregularities, this is given in 35 of CRPC, chapter 35 of CRPC, and these are the sections 460 to 466 that talks about these irregularities. Okay, first one is curable irregularity, that is section 460, and section 461 is something which is incurable irregularity, as in it's okay if this has happened, but this is not okay. Okay, so there might be different irregularities, different problems that may happen. Some are which will affect the proceeding, some are that okay fine, even if it has happened, the decision whatever has come, that would be applicable as such only.
Yes.
Depending upon irregularities in legal proceeding and its effect before the criminal courts, CRPC provides for 7 different concepts relating to irregularities. These are those provisions. First of all, irregularities which do not vitiate the proceeding. Proceeding has happened, court has maybe given such some decision or anything. Just because of the irregularity, it would not declare the proceeding as invalid or something. Okay, the proceeding, whatever happened, it would be fine only, even if there were irregularities. But section 461 is something where irregularity is not okay. It will vitiate the proceeding. Okay, it would make the proceeding invalid. This irregularity is not okay. This irregularity is okay.
Okay.
Next is proceeding in wrong place. Proceeding happened in proper way only, but place is a wrong place. Where it should have happened, there it has not happened. Some other place it has happened. What will happen in such cases? Non-compliance with provisions relating to recording of confession and statement record of examination of accused. If these requirements are not being satisfied, non-compliance, these requirements are not being satisfied, what would happen there? Effect of omission to frame or absence of or error in charge. Once before starting of criminal case, charges will be framed, right? They would mention that under this section, this is the crime for which you are charged, right? That you are accused of committing this crime. It's very much important that everything is written properly so that accused person knows that, okay, these are the charges against me. And if I want to defend myself, I need to defend myself against all these charges. It's very important to frame charges, but what will happen in case of omission to frame? Charges only were not framed, or there is some kind of problem in framing of charges. Maybe some mistakes has happened, some points were omitted, or maybe entirely charges only were not framed. What will happen in such case? Because that's also something that CRPC mentions we should follow. So what will happen if we are not following that? Finding or sentence when reversible by reason of error, omission, or irregularities. What will happen in case it is found that because of the irregularity, we need to make changes in the finding? Whatever conclusion is made, we need to make changes there. And last one is defect or error not to make attachment unlawful. So we will see all these different provisions relating to irregularity of proceeding. Okay, now when we talk about the first section, that is section 460, it talks about some kind of irregularities which are okay. Okay, so what happens here is erroneously in good faith does that thing, his proceedings shall not be set aside. Okay, proceedings shall not be set aside, as in there may be some kind of irregularities which has happened, but because of that the proceeding would not be set aside. It would not be said that no, this is like invalid, this is not applicable or something. That will not happen. Take for example a magistrate who was dealing with a case. Okay, a magistrate is dealing with a case, and by mistake, okay, in good faith, he was not having any bad intention or anything, but by mistake, what happened is some kind of irregularity happens. That maybe by mistake, magistrate issued a search warrant that you go and conduct search in this certain place and see what all evidences or things you can collect. Okay, but maybe that was not a proper situation where search warrant could have been issued. It might happen that to police officer was ordered that you do an investigation on this particular offense, or they asked the subordinate, maybe judicial magistrate, that you conduct an inquest, you see whether this cause of action is valid or not, facts are proper or not, right? Or maybe to like the magistrate said to the accused that okay, fine, along with you there were 5 other people who committed this offense, right? 5 of you together committed this offense. If you narrate us the entire story, if you tell me details about all the other criminals also, I will reduce your punishment, I would excuse you for some things. But magistrate was maybe not having power to do so, right? So there may be some things wherein mistake has happened, okay, some error has happened, but in good faith. Magistrate also did not realize that this wrong has happened. Without any bad intention, this mistake has happened. In such cases, just because this kind of mistake has happened, it would not vitiate the proceeding. The proceeding would itself not be set aside, that this is not valid, this should not be continued or something. because it was done in good faith. Okay, merely on the ground that he is not empowered, the entire proceeding would not go on waste. Okay, is it clear?
Clear, madam.
So that is the first point which we have, where yes, irregularities are there, but it is okay, it will be excused. That in good faith he has done, he was not having any bad intention, like mistakes can happen, right? Magistrates are also human, so it can be excused. But the second section, section 461, talks about some irregularities wherein his proceeding shall be void. As in, his proceeding will in itself be considered it's void, it's not applicable, it's not binding, because there is some kind of an irregularity. Okay, void as in it's not binding, it does not exist in the eyes of law. Whatever order is passed or something, it's not binding, it's not legal. So this talks about irregularities which vitiate the proceeding, which should invalidate the proceeding, whatever has happened in the court. There are different types of proceedings which may vitiate the proceeding, like attaches and sells property. We have studied, right? Attachment of property, selling of property, perishable goods and stuff, where it might be subject to naturally getting damaged, right? Magistrate may sell it. Maybe search warrant for document was being issued, right? Search warrant was being issued that collect this certain document, produce it before the court. Demand security for keeping peace and good behavior. This also was one topic we studied, right? If there is a possibility that this person may create disturbance in the society, magistrate may ask for security to keep good behavior, right? For peace and keeping good behavior. Magistrate was not having power to do that. Even after that, he has done it. Cancels a bond to keep peace. Makes an order for maintenance. If magistrate, some order was already there that to keep peace and good behavior, you sign on this bond. But magistrate cancels it by mistake. Okay. In such cases, obviously, those proceedings would be considered as invalid because it was not a proper ground or reason where magistrate could have cancelled it. This bond was very much necessary, in fact, but by mistake, magistrate cancelled it. Right? So in such cases, this proceeding will be considered as void, that this is not binding, this is not valid. The person need to continue to keep good behavior. It is binding on him. Okay, is this part clear? Second one?
Clear, madam.
So first one, there may be some irregularities, there may be some mistakes from the end of magistrate, but it's something which should not affect the proceeding as such. Proceeding would be binding as it is. But in some other cases, it would affect the proceeding. It would be considered as void. This part you can remember. It will not be binding. It will not be valid.
So this 460 is curable, 461 is non-curable.
Yes, non-curable. Because if somewhere you have given a search warrant that, okay, for this criminal trial, go and conduct a search in some place. Even if it was by mistake, that would not affect the entire proceeding as such, right? Yes, mistake was there, but it's something which is not having that much of an impact. But if a bond was signed to keep peace and good behavior, and the magistrate cancels the bond itself, that is not valid, right? This bond was very much needed to maintain peace and good behavior. So in such cases, it's something which is affecting the proceeding. So it would be said that no, this is not valid, this is void. Okay, so this is incurable. Then we have is proceeding in wrong place. We know there are different types of jurisdictions which apply.
Yes.
Right, and that indicates which is the right place to conduct a proceeding or for a trial or for any particular thing. So no finding, sentence or order of any criminal court after the matter has been decided, court would find something, right? There will be some conclusion, some findings, some punishment, some orders may be passed by the criminal court. So those orders, findings, sentence, whatever is given by the criminal court, it will not be set aside only because of the ground that enquiry, trial, or some proceeding in the court of which it was arrived at or passed took place in wrong sessions, division, district, subdivision, or local area. Just because it was done in a wrong court, okay, maybe in a certain district, the thing has happened, okay, in that district there are 2 criminal courts. Case should have gone to this criminal court technically, but by mistake it went to this court. Okay, just because it went to the wrong court, only for that reason, it will not happen that you are completely like setting aside the process itself, that this is not valid because it was done in this certain court, but it should have gone to this certain court. Okay, just because of that wrong place, just because of that wrong place, it will not be considered as invalid, but it may be considered as invalid, it may be considered as non-binding, where only if that leads to failure of justice, because serving justice is the main reason. So if it is leading to failure of justice, in such cases, yes, in such cases we would consider, but otherwise we will not consider. Something has happened in wrong court, that also would be like, okay, fine, it has happened in the wrong court. Okay, is this part clear?
Madam, this part, who decides whether the decision is taken by the wrong court? Because trial is taken place in the specified prescribed court, and that magistrate wrongly takes decision. So what is the system for determining whether the proceedings were done in the wrong place?
Yes. Take for example, it may happen that case was decided and judgment came against a certain person, and that person goes to the higher court and says that this entire proceeding itself is invalid. It should not, you know, like it should not be binding on me or something. In such cases, court may say that, okay, fine, everything else was fine only. Just that by mistake it went to the other court, it should have gone to this court. So that does not invalidate this hard work of entire 5-6 years that court has decided a matter. Like that it may say.
So can we say this is appeal stage?
Yeah, it might be at appeal stage. Yes, it may be at appeal stage, or maybe just before the case was concluded, right? Many times we see there is a provision 482 of CRTC. Okay, party may go and file a case for quashing of proceeding. That is, this proceeding should not continue because there was this irregularity. Okay, in such cases also, if party is going like in between the process also, there also court might say that, okay, maybe we can transfer it to the proper court. Maybe we can transfer it to the proper court. Okay, in between also it may happen, appeal stage also it may happen. Many times we see when the case is still pending, right? Parties go to the higher court, Supreme High Court and all, they would go file a case under section 482, like that they do. Next is non-compliance with provisions of section 164 and 281 relating to examination of witness, recording of evidence, etc. Okay, if those things are not being followed, provisions of either of such section have not been complied with by magistrate, recording the statement, notwithstanding anything, take evidence in regard of such not compliance and may, if satisfied that such non-compliance has not injured the accused in his defense on the merits, and that he duly made statement recorded, admit such statement. It may happen that his statements were like the person's when the accused person was examined, right? Record of examination of accused was not being taken properly. Recording of confessions and statements were not done properly. Even if such kind of an irregularity has happened, okay, it was not done properly. But if it is not affecting the accused person, if it is not injuring the accused person, then also it will be ignored. Okay, even if those provisions are not fulfilled, it will be considered as okay because it is not affecting the accused person. The main purpose is justice should be served. Both the parties should get the opportunity to fairly defend themselves, put their point in front of the court. If that is happening, then some kind of irregularities might be ignored by the court as well. Okay.
Yes.
Effect of omission to frame or absence of or error in charge. Again, framing of charges is very, very important to ensure that accused person is getting a fair chance to provide his defense, right? Only when I know what are the charges against me, I can prepare my evidences accordingly. I can prepare my arguments in that direction. If I do not even know what are the charges against me, I cannot give proper defense, right? So framing of charges is very important. But what if there is omission to frame charges only were not framed, some points were missing in the charge, or there is some error, some problem in framing of charge? What will happen in such cases? Okay, again, same provision here also. Unless and until, okay, unless and until the higher court, as in court of appeal, feels that it has led to failure of justice, because charges were not framed against me, I was not able to provide my defense properly or something. Okay, unless and until court of appeal feels like that yes, because first charges were not framed properly, this person has, so like there is failure of justice, this person was not given a fair chance to defend herself. If court of appeal is of the opinion, then it might happen that they are like setting aside the process. Otherwise it will not have any impact. Okay, invalid, it would not be considered as invalid because just because there was absence in framing charge or some mistake in framing charge, but it may be considered as invalid only and only if court of appeal is of the opinion that this has led to failure of justice. Otherwise it will be completely like it would be applicable that okay fine, even if charges were not framed, you got to know what are the points based on the FIR and you have given your defense also, you have submitted all the evidences also, those evidences were recorded, so you do not have a right. Court might say like that as well. Okay, is it clear?
Clear, madam.
So it has to come from the court of appeal that they feel that yes, it is in fact affecting it, otherwise it will not have an impact. Next is finding or sentence. Okay, some conclusion maybe court has made, or maybe some punishment court has given. Okay, when reversible by reason of error, omission or irregularity, when is it that you can make changes in the conclusion, in the findings that court has made, or maybe in the punishment, in the sentence that court has given? When is it that you can make changes in what has already been decided by the court only because of error, omission or irregularity? When is it that you can make those changes? Okay, again,
Yes.
you can make changes in it unless in the opinion of court there is failure of justice. A failure of justice is like the major reason. If court feels that yes, court of appeal feels that yes, there is failure of justice because of any kind of error, omission or irregularity, in such cases they can say that okay, this
And I having one
Yeah.
small doubt,
yeah,
whether the court of appeal means it is appellate court.
as
Appellate
such,
court and the court of appeal are one and the same.
as such we don't have a appellate court. Appeals can go to like sessions court also. From magistrate it can go to sessions court. From sessions court appeal can go to high court. From high court it can go to Supreme Court. So wherever it is going, that would be court of appeal. It may be sessions court also, high court also, Supreme Court also, depending on the
Yes, yes.
situation.
Yes.
Okay, depending on where the irregularity happened, on top of it whichever court is there, that will be court of appeal.
Yes.
So unless and until Court of Appeal is of the opinion that yes, because of this error, omission or irregularity, there is failure of justice, there it may be like changed that, okay, fine, this proceeding is not valid or something. We need to change this proceeding, but otherwise it would be applicable only because as such, it has not affected the parties in any way. Already court has invested a lot of time in deciding the case, so they would go for that. Next, we have this defect or error not to make attachment unlawful. No attachment made under this code shall be deemed unlawful, nor shall any person making the same deemed to be a trespasser on account of any defect or want of form in the summons, conviction, writ of attachment or other proceeding relating thereto. So attachment as in taking something, right? Like attachment of property, attachment of goods, as in something court is taking. Okay. So take for example, court has passed an order for attachment of certain thing. Okay. But there is again some defect or error. Okay, maybe some process which they had to follow, they have not followed it. Maybe they had to issue some notice, summons, etc. They have not done it. Just because there is some error or irregularity in attaching something, okay, that would not say that whoever is going to attach the property or goods, that person is a trespasser. He entered my property wrongfully. I will initiate a criminal proceeding against him for criminal trespass. It will not happen because it was happening because of a mistake, because of some kind of an error. Okay, so just because there was some irregularity, the attachment itself will not become unlawful. Plus, whoever is doing that act of attachment, you cannot file a criminal proceeding as such against that person. Okay, because again, it might happen that it is because of irregularity. So all these things, right, as such, mistakes may happen because we have so many different proceedings available. So if it is something which is not affecting the parties in any way, we can ignore it. If it is affecting the parties also, we can try to cure it, right? We can try to solve the mistake. That okay, fine, maybe we are doing this particular thing again, right? Higher court feels that okay, this certain proceeding was not proper. Higher court can say that okay, you do it again. You do this particular trial one more time properly, you do it. Or from this certain stage, you do it properly. Until framing of charges, everything was fine. From framing of charges, you do the trial properly. Like that also a lot many times court ordered in order to fix such kind of irregularities. Okay. Many times we see Supreme Court passing such kind of an order that maybe trial court has done its job properly, but High Court has decided the matter very quickly. They have not followed the proper steps. So Supreme Court a lot of times sends back the case to the High Court and says that you take your time, decide it properly, follow the steps and things like that. Okay, these are nothing but again to fix whatever problems are there to ensure that justice is served to the parties. Okay, is this part clear?
Clear.
So this is relating to irregular proceedings. What will happen in case there are some irregularities, some omissions, problems, errors, etc. in proceeding of the court.